Hi, I'm Joe Dragon, and this is Dragon Law Group's video blog. The topic of today's video, Family Law Mediation. What is it, and how can it be used to resolve your case? As a note, anything you see on these videos or anything posted at dragonlawgroup.com is not legal advice. It's for educational purposes only. Should you be in the need of legal advice, please seek the assistance of an attorney. All right, so as I'm sure you are aware, mediation exists in all forms of civil litigation. It is simply a tool used by two parties or more to resolve a dispute and reach a settlement. In family law, the three issues that must be resolved before divorce is finalized is one, division of assets and liabilities, two, potential alimony, and three, if you have children, a child custody arrangement. So if you filed for a petition for a divorce or in the middle of a divorce proceeding, that's what the court needs to figure out before it can issue a decree of divorce. All right, so when is mediation a good idea? Well, typically I advise that at the start of any divorce proceeding, the best route is to do what's called a joint petition for divorce. It's basically when both parties want a divorce, they know how they want it to look like, and they agree, and they're just requesting the court to sign off on that petition. If, however, you are not in agreement with one or all of the three issues previously described, you need to find some sort of settlement, or you will be forced to go to trial, which is very costly and time-consuming. To give you an example of this, when you file a petition for divorce or a complaint for divorce, you may be looking at a year or sometimes longer period before you actually get a decree of divorce. And there's all types of hearings and legal proceedings going on during that time. For instance, if you have children and you separate, you need to figure out immediately, or the court needs to figure out immediately, what the custody is in the interim before it enters a decree of divorce. And that's called a preliminary motion, usually filed within the first 30 days. And you have a court hearing, and it's kind of a mini trial within a trial. That's just one example of the many types of proceedings you're likely to encounter during litigation. So it's in both parties' interest to find a settlement sooner rather than later. Now, family law is one of the most, if not the most, litigated or common issues in the court systems. In Clark County and Washoe County in Nevada, for example, there is a separate department or wing of the district court that has district judges that only do family law cases. There's really no other department like that. A typical judge who's not a family law judge may have criminal and civil and random cases, but family law, because it's so prevalent, there's actual judges that's all they do. And the reason that's important to know is that the issues the judges face and the issues the law contemplates is flushed out. The law has pretty much straightforward answers, no matter how unique your situation might seem to you. And there are situations that are truly unique, but most of them, judges have seen it before, attorneys have seen it before, and there's really not a question as far as, well, what's the likely outcome of this case in most cases. So a mediator is an attorney, or a lot of them are actually ex-family law judges, and so they are very well educated, and they know the law and what's the likely outcome of your case is, and they're very persuasive as far as getting to the bottom of it. So maybe your spouse might be difficult. Unfortunately, family law is an emotionally charged situation, and not everybody's reasonable when you're in the middle of it. So it can be difficult to reach a settlement just between the two of you. And your attorney can only do so much as far as settlement negotiations, because the fact is the opposing counsel or your spouse probably doesn't trust you or your attorney that much, because let's face it, they're representing your interest, not their interest. So because of that, it can be difficult to reach settlement. Now, a mediator is hired by both parties to come to a resolution. The mediator does not represent either you or your spouse's interests, unlike your attorney does. Their sole goal is to resolve those three issues quickly or efficiently and correctly. With that said, some of them are expensive, at least may seem expensive. Some of the mediators I know can charge anywhere from $300 to over $600 an hour, which may seem intimidating, but in the long scheme of things, you have a 4-hour mediation hearing, maybe some prep time that the mediator needs. It's much less costly than dragging out in litigation trying to solve these issues on your own if you can't come to a settlement on your own. So this is how it works. There are mediators that you can hire. Ask your attorney which one she or he thinks is a good one for your solution. Dragon Law Group, we have a list that we go to that we think are effective, and that may be different depending on your situation. I've also posted in the blog related to this article, this video, the Clark County government page that has information on mediators, so you can go take a look at that. And how it works is once you select a mediator, both of you hire him or her, and you go and meet. Now, before the mediator meets with you, she or he is going to want all the relevant facts and details and documents pertaining to your divorce, things like financial papers, bank account statements, figure out what those are. A lot of times one spouse maybe kind of took the lead on the finances and the other let him or her do that and doesn't really have a good grasp of what the finances actually are. Your attorney can assist you in figuring that out and gathering everything you need. Anything that has to do with child custody, any major issues as far as child custody is concerned, the mediator is going to want to know about that. Either yourself or your attorney will write a statement, basically explain to the mediator, okay, this is what the case is about. These are the issues that are resolved. These are the issues that aren't resolved. And here's all the relevant information on those issues. And here's why we think it should be ruled in one way or another. And then the mediator then takes that information, prepares, gets an idea what the case is about, meets with both spouses. It varies. Typically, the longest you're going to see is about 4 hours, some 2 hours, some maybe longer, depending if there's a lot of complex issues involved. And each side will then explain to the mediator what they would like to see, how they would like to see the issues resolved. And it kind of goes back and forth until the mediator basically says her or his suggestion. And so this is basically how the trial would come out anyhow, and this is a fair and reasonable outcome. Now, mediation does not compel; it's not binding. So the mediator can't force either party to actually agree to anything. He or she's going to make suggestions and explain why. If mediation is not, if a settlement is not reached, then the mediator informs the judge that settlement cannot be had, and the case continues. I will say that in the majority of mediations, resolution is reached because, like I said earlier, the law is flushed out on this issue, and it's not that difficult to see how trial will play out. Some mediators are better than others, so make sure when you're selecting one that you talk to an attorney or talk to your attorney and really figure out which one is the best for your case. It is a great way to resolve a case. Frankly, you don't want divorce dragging on forever. It's about turning the page and moving on to the next chapter, and that's what a mediator can do. So if you'd like to know more, please feel free to contact us. You can email me directly. My email is joedragon@dragonlawgroup.com, and I will look forward from hearing from you. Thank you very much.